Okay, so now it should be recording. So we'll wait another minute and then we'll proceed. For those people on, it looks like we got about 15 attendees at the moment. If you have a question throughout, we have a lot to cover, but we'll try to answer any questions we have time for. You can post your questions in the Q&A box. You should have a little icon on your screen that says Q&A. And either of us will try to get to either typing an answer, or if it's something we think everyone should hear, we can share it with the crowd. But other than that, I think what we'll do is get underway. We have a fair amount to cover, some interesting stuff, some new things in the hopper. Oh, we got something with the Q&A. At what point can we ask questions about terms? Well, anytime you like. And again, we'll try to answer it. Something with a question like that, we'll probably just put it in the chat, in the question and answer box. We can answer the question. So we'll go for that, Marian. All right, so let's get underway. This is 2021, and certainly we hope as the year progresses and things are improving out there with the pandemic that we've all been dealing with for seemingly forever, we should hopefully see better things ahead in the last 3 quarters of the year, and certainly numbers are starting to improve and things are feeling a little more open and free, and I'm certainly happy that I got my vaccines and we're feeling better about stuff. So hopefully everyone is doing well and we've gotten through the worst of it. Okay, so we always start off with some firm news that's transpired. Last fall, we did have a new attorney join us, Susie Sohn, who is a Goshen native, Goshen High School, and she worked for the New York City Law Department for a good decade or so, handling complex contractual matters. She will be primarily working with Michael Bluestein in the transactional area, and also Will Frank with the municipal law. But she's helped out on a few things in our world and is very versatile. And for any of you who are fortunate enough to meet her, you will definitely enjoy her positive and optimistic outlook on things. So we look forward to everyone getting a chance to know Susie. So we're going to talk about some of the document updates. So Megan, why don't you take us through some of this?
Sure. So in last year's meetings, we talked a lot about the Secure Act. That was the new legislation, sort of the hot topic, or one of the hot topics for last year. And that, as a reminder, really affected your retirement accounts, and specifically how your beneficiaries, non-spouse beneficiaries, would take distributions once they're inheriting those retirement accounts. So pretty consistent with the changes that we started making last year. A lot of our language in our revocable trusts and our wills, and we'll get to the retirement trusts in just a few minutes, have been updated so that we can make sure we have language in there that reflects that new legislation, and really can adapt to your family and the different beneficiaries that you might be naming. So we have the conduit trusts, which is the kind of old style trust language from before the Secure Act that we used very broadly, pretty much in most situations. You would see those conduit trusts. And the conduit trusts are going to continue as that default option for things like the marital trust. So things that you're going to set up for the surviving spouse, because that new Secure Act legislation is not going to affect the way the surviving spouse is going to take their distributions. They'll still take it based on their life expectancy. So you'll see conduit trust language in the marital trusts, which appears in your revocable trusts and in your wills. We also have protective language included in those revocable trusts and wills, so that if you do have any supplemental needs trusts being created, and even if you don't have them as an outset trust, we also, you're probably familiar enough with it in your document by now, but we always have supplemental needs trust language as a safety net in your document somewhere. So if that supplemental needs trust ever is needed for any of your beneficiaries, we're not going to use the conduit trust language there. We don't want to force out distributions, which is exactly what the conduit language would do in the case where someone is qualifying for benefits. So really making sure that our language is nice and clear everywhere it's supposed to be throughout the trust, conduit language appearing where it's supposed to, but obviously not appearing where it should not be going, because it wouldn't be beneficial to your children or other beneficiaries you might be naming. There are also some software options to allow for conduit trusts, again, where applicable, for those beneficiaries who might still benefit from the conduit trust language. Those would be the beneficiaries that fit into the exceptions under the Secure Act. So for minor and disabled beneficiaries, or beneficiaries not more than 10 years younger than the trust maker, we would still typically want to apply that conduit trust language there, so that those beneficiaries can still take advantage of the stretch out that's available to them, because they fit in that carved out exception within the Secure Act. So again, always kind of trying to clean up that language to make sure we have the provision where we need it, and then otherwise we're having accumulation trusts in most of the other provisions because of the Secure Act.
Right. So bottom line, if you don't qualify for conduit trust provisions, you have to, as a non-spouse beneficiary, withdraw the IRA or other retirement account within a 10-year period. And if we have the trust structure, it'll be payable first into the trust, and then the trustee, whether it's the beneficiary or someone else, can decide whether to take it out of the trust or keep it. If you're in the group of people who meet the exceptions, like a minor beneficiary, at least until they're 18, or classic case, we have clients who don't have children and want to leave it to a sibling who's 5 years younger, then they can still use the conduit. And then when that sibling inherits the IRA, it can be paid out over their life expectancy, which in most cases is going to be more than 10 years. So the flexibility, as always, is the key. So moving ahead, there we go.
So as Rich already kind of alluded to, for those beneficiaries who are not going to be able to take advantage of the stretch out that's available within the exception, we don't want the conduit language for those folks. So instead, we have those accumulation trust options, and that will really be the default unless the beneficiary falls into one of those exceptions. So going forward, as we have updated your trust last year, we probably have talked about this quite a bit, and even continuing on for the future, we're always going to want to ask you about who your beneficiaries are, and do they fall into one of those exceptions? Are they minors, or are they within the 10 years of your age, or are they disabled? So expect those questions, or maybe just offer up the information, put it on your worksheets if you know it's coming, but likely we have talked about this a lot already. Those accumulation trusts, you probably remember a little bit from last year, but they can include some discretionary withdrawal language, but it doesn't force out the distributions. It doesn't force any funds out to the beneficiary directly. And so it allows the retirement, as Rich said, the retirement distributions to be payable to the beneficiary's trust, and then they can take the funds out if that makes tax sense for them, or if they just need to use the funds. But it's really up to the beneficiary and the trustee's discretion as to when to remove the funds from the protective trust structure, rather than forcing those funds directly out to the beneficiary.
Yeah, and one provision we have included now is to the second bullet point, to ensure that the Roth IRA distributions, which many people have, that would go into a trust share for somebody, are treated as non-taxable distributions. So there's just some clarifying language for that. And then we may have mentioned this last year, but we do have the power for clients who have, impaired vision, which especially in some older folks, that's an issue. We have gray boxes where people for their signatures, just to make it easier to see where to sign in the document. So not a substantive change, just a practical kind of enhancement. So that'll move us into the legislative realm and where we are from the estate and gift tax world. So Megan, why don't you tell us where we are right now?
Sure. So first, yep, we'll take a look at the estate and gift tax exemptions. And some of this is going to sound like the same thing that you've been hearing for the last several years, right? So each of these numbers have increased a little bit with inflation. So for the federal estate and gift tax exemption, that lifetime gift tax exemption, we're up to $11.7 million per person. Again, up just a little bit from last year. And the New York estate tax exemption for this year has also increased a little bit. So we're at 5.93 million per person. There is no, as a reminder, and I think we mention this every year, but there is no separate New York gift tax. So that's really just federal. But for taxable gifts made within 3 years of someone's passing, those gifts, those funds that have been gifted are going to be recaptured. So they're going to be included as part of the estate value. So not so much gift tax, but no on gifting. The annual gift tax exemption for 2021 remains $15,000 per person per year. So that's the number that we've had for the last few years now. You're probably pretty familiar with it by now. And again, we let you know about the gift tax and things like that, but that is not so much the conversation around gifting. Typically, our conversation is going to be more to do with Medicaid. So just keep that in mind. Even though it might not be a taxable gift, if you're making gifts, just run it past us first because there could be Medicaid implications there. And both federal and New York State exemptions are indexed for inflation, which is why we see those rising a little bit each year so far.
Right. So all these numbers, which are quite expansive, of course, means that estate tax planning, even for New York residents, applies to a minute portion of the population. Well, might we see some changes in the horizon? Well, there is a bill that's been introduced by Senator Bernie Sanders, and that has some traction out there, given the concerns about deficits and all the stimulus and so on that's had to go out. Some of that's going to be paid for, of course. So what would happen if the Sanders legislation or bill was enacted into law? Well, that would reduce the federal estate tax exemption back to the 2009 level of $3.5 million per person, remaining indexed for inflation over time. So portability would be retained, which allows easily for 7 million of federal estate tax exemption for married couples. For those in excess of the exemption amounts, there would be a graduated tax starting at 45% for assets in excess of the 7 million, or actually the 3.5 million per individual, up to 10 million, with the percentage of tax increasing on higher amounts above 10 million. I think it's from 10 million to 1 billion, it goes to 55%. What might even be a more dramatic and serious change for a lot of people is the possibility of the loss of the unlimited step up in cost basis. So just a little refresher, today you could have a stock, let's say you have $1 million worth of Apple stock that you paid $10,000 for. So your gain is $990,000. Right now you get a step up when you die, your kids inherit it, they sell it for $1 million, they pay no tax. Well, that would still be the same under the new law, because you would get $1 million of exemption for step up in cost basis. But let's say you had $2 million that you paid $10,000 for. Only the first $1 million would get the step up. So if your kids sold the entire $2 million, they would pay no tax on the first $1 million of sale. On the second $1 million, they would pay whatever the capital gains rate is for them. Let's say it's 30%. So you figure about $300,000 of tax. So yes, not only could that dramatically, change the landscape of inheritances and taxation, it'd also be a very difficult thing to juggle with from calculating cost basis, because many people have inherited stocks over the years and they've split. And if you haven't kept track of your cost basis and you can't prove what the cost basis is, the IRS will presume it's zero, which means every dollar will be subject to capital gains tax. So it's going to be an accounting hassle. We had this happen twice in the last, say, 50 years. We had 2010, it went away for 1 year that year, and also I think in 1986. But this could be, quote unquote, a permanent change if the the legislation passes. Also importantly, the lifetime gift exemption would be under this proposal reduced to $1 million back where it was prior to 2014 versus the 11.7 million. So while still relatively few people would be paying gift tax, certainly a lot more will be implicated if you're giving valuable real estate away or business interests that have a lot of value. That's where the gift tax can become a real thing again. So a lot of possible changes on the horizon. And for the more advanced planning we have, there would be the proposal to eliminate the discounts for valuation of family business entities. We do a few of these plans every year where we get a valuation done, and a company, say that's private companies worth $3 million on paper with a good valuation report, they can reduce it to say $2 million because of various lack of control and lack of marketability discounts. Those would be eliminated in the family context in the legislation. It also would be proposals to eliminate other planning tools such as grant or retained annuity trusts or GRATs, and in another structure called sales to intentionally defective grant or trust. And lastly, the gift tax exemption, which is now $15,000 per person per donee. You can have 30 people and give $15,000 away to without gift tax implications. That would be capped under the proposed legislation to no more than $30,000 per donor. So if a person who gives away the money gives away more than $30,000 in gifts, there would be taxable effects for more than the $30,000 per year. So again, this is just one of the many proposals that are out there. I know some estate planners, maybe to get some business, are out there running around to their wealthy clients saying, oh, you got to plan this year before all this happens in January. Now, it may, but I am not quite as alarmist about it because it would require a complete, every Democrat in the Senate to go along, which is not a certainty. I could even see, Chuck Schumer, as liberal as he is, not being too in favor given all the wealthy New York constituents he deals with, right? That's just a practical effect. So while 3.5 million may not be on the card table, maybe it'll come back to 5.5 million as a compromise. I sort of see that more likely. And maybe, they'll reduce the gift tax exemption instead of 1 million to 4 million or 5 million. Who knows? We'll keep you apprised, of course, as we always do, regardless. We have one question: does the step-up max include all assets? Presently, it does. The only assets that don't get a step-up are annuities and retirement accounts. Those are considered income in respect of a decedent, so there is no step-up in basis for those assets. But pretty much everything else, stocks, bonds, real estate, cash. But stocks and appreciated real estate are really the most prevalent assets that we are dealing with. So that's one big possibility that we have to keep our eye on. Now, here's something we know is going to happen, but we don't know quite exactly yet. We think we know.
So this is and I think we did talk about this maybe a little bit last year as well, but this is the new rule for community Medicaid. And prior to this new rule, there was no look back. So, in the past, we've never really talked about a look back period and community Medicaid. We're always talking about the look back period with nursing home Medicaid. But with the budget that passed last year, we knew that this was taking effect at some point. We just weren't sure at what point it's going to be effective. There is a new 30-month look back period for community Medicaid. So we keep kicking this can down the road. You probably heard about it coming into effect October 1st of last year, then a few more times since then. Now we're looking at an effective date of January 1st, 2022. So starting with the new year. And so that would be for community Medicaid applications that are submitted on or after January 1st, 2022. And again, this date could also change. I don't know if it will between now and then. Hopefully things are going to be stabilized, and we can kind of rely on this date, although we don't really want this to take effect. But this look back period is very just like the look back period for nursing home Medicaid. So what we're looking for in the 30 months before you submit your community Medicaid application are all of the non-exempt asset transfers that you would have made. So now on that January 1st date, we're looking back to October 1st, 2020. So last October, any transfers made since that last October until whenever you submit your application going forward, those are the transfers that we're going to be looking at. So transfers made prior to October 1st, 2020, we're not that concerned about for community Medicaid purposes because this new rule is not going to apply to those. But again, it's subject to the 30-month look back period. So there would be a penalty for any transfers made within that look back period since that October 1st date. Again, this change puts us, New York, in conformance with most other states. So most other states have had a look back period for community Medicaid, and we've just sort of been lucky for this time that we didn't have one. So we had a lot of planning opportunities available to us. Not to say that we don't have planning opportunities available to us still, and we're going to talk about a lot of that today, actually, in our spotlight. But now we just have to be aware of this look back period for community Medicaid as well as nursing home Medicaid. And spousal refusal is still available to us as of right now. So again, that's something that we really take advantage of here in New York. We have this spousal refusal, which allows us to shift assets between spouses, put them all into the well spouse's name to preserve most, if not all, of the assets when we're submitting that application. So we still have spousal refusal available to us as a planning tool in the crisis situation as well. So not all is lost with this new look back period that we have. For the new look back period, to determine the penalty period, we do a little bit of math. We try to figure out what the total value is of all of the transfers that have been made during that look back period that's effective. And we divide it by the average monthly cost of a nursing home in our region. So for 2021, that divisor is actually $13,206. And you're saying, wait a second, I thought this was community Medicaid. What does that have to do with nursing homes, right? Well, luckily, and I say luckily because we want a large divisor for this formula, luckily, they want to keep the math the same. And so we're going to continue to use the regional rate for nursing homes, even though we're talking about a community Medicaid look back period. And that actually means that our penalty period is going to be a bit shorter for those transfers. So we like that it's a nice high divisor and that the math is going to be the same. And so determining if an applicant is medically eligible, this is another thing that was sort of updated. This is going to change because now they are requiring for community-based services a functional assessment. So it's going to be on a chart. It's more defined. It's kind of easier for us to go through and say, do you check the boxes to be medically eligible for these community-based services? So the functional assessment is going to be performed by a medical professional, right? And it has to be done in order to become eligible for the community-based services, and that is necessary to start the penalty period running. So if we are looking at transfers made within that new 30-month look-back period, we then want to say, all right, we have to make sure that you get this assessment done so that you are now eligible so we can get this penalty period started. Whereas with nursing home, I think it was a little more obvious because you're entering the nursing home, you're there financially and medically, you need the care. So here we have a functional assessment in place to get that penalty period going for you.
Yeah, and to trigger the trigger the eligibility through the functional assessment requires a slightly higher finding of disability. It used to be, I think you just had to have 2 activities daily living that you need assistance with. Now I think it requires 3, but there's some combinations that are different. There's a whole calculation. Realistically, if people need help with 1 activity of daily living, which is, dressing, bathing, etc., they tend to need most, if not all of them. So that, I don't know how practically that's going to change things. So one of our biggest things that is in place besides the community Medicaid rules is a new statutory power of attorney. We've been dealing with this overblown or bloated power of attorney with a gift writer since 2009. And we attorneys have not really liked it as a general proposition. It's very difficult, confusing for people to sign if they're not sitting there in front of the lawyer. With many times they're signed incorrectly and not initial. So since I think, well, actually it says here, on the next slide, since 2015, the Elder Law and Special Needs section of the New York State Bar Association, I'm on the legislative committee for that group. We've been proposing changes to the New York Power of Attorney law. And it's been introduced in the legislature every year for the last 6 years. Finally, at the end of 2020, the legislation, despite significant opposition from the banking lobby, was passed by the legislature and was signed into law by Governor Cuomo on December 15th. And it will be effective. There's a 6-month waiting period, presumably so the financial institutions can train their personnel on how to use it properly, how to deal with it properly. So here are some of the key provisions under the law. So one of the biggest bugaboos we've been dealing with under the existing legislation is what's called the exact wording requirement. Technically, if you miss a period in the form or a comma, a financial institution could properly reject it. If it didn't meet the exact wording exactly as in the statute, that thankfully is now changed to substantially conformed requirement. So no longer can a financial institution reject a power of attorney for a typo. And now you may say, and people say, well, what's the big deal? Why do the banks care? Well, they don't like powers of attorney. We've dealt with this for years. They're always afraid that somehow they're going to be under increased liability, even though the statute has always shielded them from liability if they act in good faith in accepting a power of attorney. But banks hate them, again, because they're just checking the box of something they don't like. No real practical reason for it. We're happy to say there's not going to be an ongoing gift writer anymore. All the gifting provisions, which are very important to have for Medicaid purposes, will be within the main power of attorney. Only one document to sign, not two. This is really helpful. The third point, we have many people, visual issues or physical limitations, who cannot physically sign the power of attorney. Now, a person can direct someone who's with them to say, you sign on my behalf, and that will be considered a valid power of attorney. Again, a recognition that many times these are being signed by people in a sort of physical or crisis at that moment, and this just facilitates having these put into effect. One thing that the banking folks insisted upon, and that we agreed to as a legislative committee and the state legislature enacted, was to have a notary and 2 witnesses instead of just a notary. And that's fine, because the notary can be one of the witnesses, so you just need one other person just to verify the person signing it. The next point is very useful, that if there are 2 more agents who are acting together as co-agents, then even if it says they must act jointly, one agent can delegate authority to the other agent. This can be very helpful for those of you out there who, say have 2 kids, very common scenario. And ordinarily we'd say, well, if you allow them to act separately, that's great. And we generally would encourage that just for ease of use. But there's always a concern, well, what if one of the kids does something the other didn't know about or wasn't on board with? Well, here, if you do require them to act jointly, they can still delegate to each other so that they can act independently with the appropriate delegation. So you got that protection that one is only acting with the knowledge or consent of the other, and yet it's not going to make it logistically more difficult to physically carry out what you need. Another big change in the law is that there are now going to be penalties imposed on third parties. Not everyone, like government agencies, aren't going to be penalized, but financial institutions, etc., are going to have repercussions if they do not, or if they improperly reject a power of attorney. First of all, they must have reasonable cause to reject the power of attorney, which is defined in the statute. And there's a timeline. They can't just sit on it and never act. They have to act within 10 days in writing after the power of attorney is submitted for acceptance in order to decide whether they're going to accept it or reject it. The third parties can request an attorney opinion letter that the attorney would state in writing that it does meet the statutory requirements. And if we're the ones preparing it, we'll submit that letter. If the POA is in fact rejected by the third party, then we can file a response to the rejection. Within 7 days after that response is submitted, then the third party must either finally accept it or finally reject it. If it is finally rejected, then the submitting party can file a special proceeding in court to compel the third party to honor the power of attorney. If the court agrees that the rejection was improper, then for the first time, there can be damages and reasonable attorney's fees imposed against the rejecting party. So no longer will banks and brokerage houses be able to arbitrarily just say, we're not going to accept your form. And I just had one last week where it was said it was too old. There's no such thing as a power of attorney that's too old. It could be 100 years old. If the agent is still living and the principal is still living, it's still a valid PO unless it's been rescinded or revoked. No longer are we going to run into these, hopefully, and we'll see far, far fewer instances of third parties rejecting the power of attorney. And now we can go to court and have them pay the cost for getting them to do what they should have done in the first place. So this is really a very big deal for us and for you, because unfortunately, many times we don't know if a third party is going to reject the power of attorney until the person, the principal, is no longer have the capacity to sign a new one. So we're between a rock and a hard place. We should not have that issue going forward on any substantial basis. Now, the law, as I said, goes into effect on June 15th when the new form will be released. If you are coming in for your update before then, you will, if you need a new updated power of attorney, we just give you the current form. It doesn't mean that any POAs executed before June 15th are invalid. They will still continue to be valid. But certainly anybody who's coming in after June 15th, or if you're coming in next year and haven't signed one this year, you will get the new form and the more simplified structure. So that's all good news. We're very happy about that. So that's all the legislative stuff that we have. I think there's one other question. Which updates are only proposed in ones that have been passed as law? I'm not really sure what you mean by that. The power of attorney law is in place. The estate tax scenario we described is just a proposal that is not put into law. So hopefully that is what you're looking for. If you have a further question on that, you can touch base with us offline. So now we're going to shift into, as we always do, a couple of cases of interest. Last year we had a wealth of cases to choose from. This year wasn't quite as rich a reservoir of cases, but Megan found a couple of very good cases out there. We'll pick up on that. Someone just asked, is slide 10 and 11? I'll have to look at what those are and get back to you on that. Okay, so let's take care of that later. So,
yeah, I do think that slides 10 and 11 are the proposed law.
Oh, they are. Okay, those are okay. Thanks for clarifying that. That's the estate tax law?
Yeah.
Yeah. So that would be, those are just proposals. Nothing is enacted on those.
Right.
Okay, so let's talk about our couple of new cases this year. So Megan,
Sure.
we'll hit the road on those.
So the first one, Gale versus Regis, this actually came through, I think, the beginning of this year. And it's an interesting case. This is actually a wrongful death action that was brought by a surviving spouse, the surviving wife of a decedent. And when she brought this case to the court, it's against a nursing home. And the nursing home said to the court, well, wait a second, there's this arbitration agreement in place. So the nursing home is requesting to compel arbitration pursuant to that agreement that had been signed. But that agreement document was signed by the decedent's daughter. So the facts of this case are that prior to the decedent's passing, he was admitted to a nursing home, and that's what the claim was filed against that particular nursing home. And at the time he was admitted to the nursing home, he was found to be suffering from different physical and cognitive impairments to the point where he was unable to really legally express his wishes or sign off on any documents. So he didn't really have capacity to make decisions on his own behalf. And that's not all that unusual when someone goes into a nursing home. That's not to say that every person, obviously, who's admitted to a nursing home doesn't have capacity, but this does happen sometimes. But in this particular individual's case, not only could he not voice what his wishes were or who he would like to make decisions for him, but he had no legal documents in place to make for decision makers, right? So he had no healthcare proxy and no power of attorney that he executed. So kind of a difficult situation, but luckily New York does have the Family Healthcare Decisions Act. And under that act, it allows for surviving or a well spouse or adult children and different people in an order of priority to be able to go ahead and make these healthcare decisions on behalf of someone who can't make their own decisions when they don't have a healthcare proxy in place. So in this case, the decedent's daughter was the person who was making all of the healthcare related decisions for her father. She was speaking with the doctors, making sure that her mom was in on the conversation, but she was really the one making the decisions and effectuating the paperwork for her father.
Okay, move ahead.
So the daughter signed a handful of documents, healthcare related documents. She also executed the nursing home's admission agreement, which they'll require anytime someone's being admitted into the nursing home. And attached to that admission agreement was an arbitration agreement. So it was not part of the admission agreement. It was an optional section that was kind of attached to the back, which said that if there was anything that the family wanted to bring against the nursing home, they'd have to do that through arbitration instead of bringing it to court. So here the court held that while the daughter's authority to execute all of those medical treatment forms and the admission agreement on her father's behalf was permitted, so the execution of those documents was permitted under the Family Healthcare Decisions Act, she didn't have a power of attorney over her father's affairs. And that's an important distinction. So the court here ruled that because the execution of the arbitration agreement was not an act related to the daughter's medical decision-making authority under the statute, wasn't a medically related decision, she didn't have authority to execute that arbitration agreement and make that decision for her father. So here, the estate was not actually bound by the arbitration agreement, even though it was signed. The court said that the daughter really shouldn't have signed that under the Healthcare Decisions Act, and she didn't have authority to bind her father's estate by that.
Right. So really a clear distinction between the medical decision-making authority under the act versus financial decision-making, which is would require either power of attorney or presumably a legal guardianship under Article 81. And so this really acted to the benefit of the state that she did not have the broad powers that the nursing home attributed to her.
Right.
So our second case is similar to one we had a year or so ago, maybe 2 years ago, about a missing will kind of case. So here, no one was contesting the submission of this will, which is a little surprising because of the money involved here. But here, Mr. Balducci died, and it was a simple one-page will, leaving everything to his girlfriend, obviously not a spouse, who was his sole beneficiary. Under New York law, a copy of a lost or destroyed will can only be admitted to probate with the following conditions. One, it has to be established that the will has not been revoked. Two, the original will was properly executed. And three, it has to be shown that the copy is a true and complete copy of the original. So this really hinges a lot on testimony or affidavit of someone who had control of the original will. If it was in the testator's or decedent's home and no one has seen it and they only have a copy, it's going to be very hard to admit it because the person who had custody of it is now dead. But in this case, Mr. Balducci, who had an estate of approximately $8 million, no kids, so his heirs without the will would have been his 6 first cousins. What was critical in this case is that the original will was last known to be in the possession of Mr. Balducci's longtime accountant. So to get the copy admitted with the same effect as the original, and of course it was the girlfriend who had a lot riding on this, because if the will was not admitted, she gets 0. Everything passes to the cousins. So she got an affidavit from the accountant that said essentially that Balducci had asked the accountant to retain a number of Mr. Balducci's important documents in the accountant's safe, including the will and documents pertaining to a sale of property. I'm sure for tax purposes, they kept those records. 4 years later, the Balducci said to the accountant, "No, you don't need to keep any of those documents anymore. Everything should be, past the statute of limitations for the IRS, 3 years, you're good to go." So while the accountant destroyed the sale documents, apparently he accidentally destroyed the original will, which wouldn't be hard to do. It was only a single page, so it probably got just stuck with some other papers. All right. So the court, though, based on the accountant's affidavit, determined that all conditions for probate of a copy were satisfied, and they did in fact admit the copy as an original. The record was able to establish that Balducci himself had not destroyed the original will, but had given the instrument to the accountant for safekeeping. And the court further found that the propounded instrument was proven in accordance with the statute. So even though both of the attesting witnesses to the will had predeceased Balducci, the accountant's affidavit identified the handwriting of Balducci and one of the witnesses as required by the statute. Now, personally, I think that's a little far-fetched. How is the accountant going to recall? The only thing I would say, unless maybe one of the witnesses was one of his staff people and he had documents that he or she had signed. That'd be the only thing that I could see that made sense. And the court also accepted the accountant's assertion that the propounded copy of the will was an exact duplicate of the original. Again, I guess this is one advantage, that it was only a one-page will. It's easier to make a credible claim that, yeah, I remember it's one page, everything looks the same, I remember. So, I think my guess is, Megan, that the accountant and the girlfriend had a little side deal going on. You get this admitted, I'm going to cut you $500,000 or something like that.
Exactly.
Let's be practical here. What's the moral of the story? Well, they got lucky, but the real moral is, as we've said to you many, many times, this is the reason we keep the originals here in our safe, because we know what they're all wills, they're not getting destroyed. And if it leaves our office, and we have a few clients who have signed and want that original will, we have them sign a receipt that they've taken the original. 50% of the time, I'm going to tell you, it's either going to get lost or torn up or something screwed up with it. Mostly lost. So that's why we keep them here. Your kids who are going to administer your estate decide they want to use someone else to be their lawyer, we'll be more than happy to turn it over to them. But at least we know we'll have the original available to provide. So a cautionary tale and sort of an interesting set of facts. So now we're going to move ahead to our planning spotlight. We always do a planning spotlight. Last year we talked about powers of appointment. This year we're focusing on crisis Medicaid planning. Now, many of our clients, and probably most of them, have some form of Medicaid planning in place through use of Medicaid trust, proactive planning. But it's very important, we think, for people to know the rules regarding crisis Medicaid planning in the event you have a situation personally, like we don't get through the 5-year look back with your Medicaid trust if you have one, or maybe you have parents who you've been begging to get planning done for years and never do it. Then the crisis arises. There are solutions even under that situation. So let's move ahead and talk about our crisis Medicaid plan.
So for the crisis Medicaid planning, and when we're talking about Medicaid planning in general, it's mostly a middle class problem. We talked about the estate tax exemptions, and we revisit this together every single year. But as you know, the estate tax exemptions are very, very high. So few people are really worried about planning for estate taxes. So instead, our focus really is shifting to Medicaid planning and making sure that assets are protected. So again, we see the New York State exemption being at 5.93 million and rising. Federally, we talked about $11.7 million exemption, but we know that there are some proposed laws and legislation coming through that could change this a little bit, but still very high exemption rates. So few people are worried about the estate taxes, like we said, and more are considering the cost of long-term care. And so you'll see that regional rate that we referred to a little bit earlier on, the average cost of a nursing home, monthly cost, I'll emphasize that. This is the monthly cost of a nursing home in our region is $13,206 per month. And so that is the updated 2021 number from the Department of Health. They kind of determine that regional rate for us. So this is the cost that we're looking at, and we're faced with for the average American, the middle class person who doesn't have a net worth above those estate tax exemptions. This is where your concerns are really lying. So how do we pay for that care? And paying for long-term care can be done a few ways. You can privately pay for that care, so out-of-pocket payments using your assets that you've acquired and accumulated over the course of your lifetime. For those of you who are lucky enough to have long-term care insurance, and by lucky enough, I mean you knew enough in advance to start looking into this. You were healthy at the time that you applied, right? So you were able to get an approval and get a policy, and that you have enough to be able to afford that premium, which seems like every year I'm getting calls from clients saying they're increasing my premiums a little bit. What should I do here, right? So long-term care insurance is great, but not everyone has it. So then we start looking at Medicaid and using Medicaid as the payer of last resort to cover this cost of long-term care, because we may not have that long-term care insurance and we don't want to privately pay and spend everything that we have and we've earned on the cost of long-term care, leaving nothing for our children or our next level of beneficiaries. So that's how we're paying for long-term care. Medicare, and this is an important reminder because I think sometimes people get confused. Medicare and Medicaid sound very similar, right? They're both government programs. Medicare does not really cover your long-term care. So Medicare will cover no more than 100 days of skilled care, but there's really no guarantee for that 100 days of coverage. First, the hospital has to classify that care as rehab, as skilled care, in order for Medicare to even pick up a portion of that bill. If that's the case, then the first 20 days would be covered by Medicare in full. But then after that 20 days, there's typically a deductible that you're going to be paying. So the remaining 80 days would require some kind of daily copay on your part. So not completely covered by Medicare, you're going to foot a little bit of that bill. Also, a person who has Medicare covering this kind of skilled care, that they can be cut off at any time if they no longer require the skilled care. So your progress will be noted and they'll be keeping track of this. And if at some point they determine that you're really not progressing the way that you should be, then Medicare is just going to stop paying the bill. So you're not even going to get the full 100 days that you might be relying on or expecting. If that were to happen, you would receive a notice. So they would say that your Medicare coverage is ending for this stay, and there would be appeal instructions, but it's a hassle that I'm sure you don't want to go through if you're in that situation. You're already receiving some kind of skilled care or rehab, and now suddenly you're faced with having to go through an appeal so that someone can pay for this kind of expensive care. So Medicare is not what you are going to be relying on to pay for your long-term care. That's not where you want it to be. Instead, we're going to be looking at Medicaid. And specifically, in order to qualify for Medicaid, you have to meet certain financial levels. So for those of you who have done some proactive planning, we've talked about these look back periods and trying to maneuver your assets to protect them. And all of that is so that when the time comes that you need to apply for Medicaid to pay for your care, we are that much closer to meeting these financial thresholds. So let's take a look at some of these levels that we have. And each year, these numbers are going to change a little bit. So if you haven't seen this in a few years or heard about it in a few years, you'll get nice updated numbers. There is a limit on the resources, the assets that you can have in your name. So at the time you are applying for Medicaid, you can have no more than $15,900 of total value assets in your name, typically not including your primary residence. You're allowed to also keep a vehicle, but otherwise, this is going to be your cash accounts, your checking and saving, your investments, money market brokerage. It's the cash value of your life insurance, non-qualified annuities. So there are a lot of assets that you may not be thinking of immediately, but they're all counting towards this $15,900.
Yeah, one thing that doesn't count is your IRAs or 401ks. If you're in payout status, so if you have a 500,000 IRA and you take 40,000, the 500,000 will be exempt, but the 40,000 of income will count towards your income contribution.
Exactly. And so that's a perfect segue for income, because there are also limits on the amount of income you can keep. This is not whether or not you are eligible, although if you're receiving a whole lot of income, enough to completely cover your care, then we may not be looking at Medicaid anyway. But there are limits on income. So for a non-institutionalized individual, meaning that this person is receiving care at home, they are not in a nursing home, they are allowed to keep $904 per month of their income. Technically, the excess is supposed to get paid over to cover some portion of their care, but where there are planning tools available to us that we can actually preserve your excess income using a pooled trust. And I do think we take a closer look at this in just a few slides. For those folks who are looking at a assisted living program, so you're going to move into assisted living facility and receive care there, you're allowed to keep $1,488 per month of your income. And again, we have the 2021 designation because these numbers fluctuate a little bit each year. They go up a tiny bit typically. But so if $1,488 is the amount of income that you can keep, excess is supposed to get paid over to cover your care. But again, this is considered a community Medicaid, and so we can use the pooled trust option to preserve some of that excess income if your income is over the $1,488.
Now, one thing that can be tricky about the assisted living program is that not every assisted living facility, nor even every bed in the facilities that accept Medicaid will qualify. So we have a few in our area. There's Braemar and Promenade in Middletown, Mount Alverno and Warwick, and I think there's one other I can't remember off the top of my head that participate in the community Medicaid program, but like Sapphire and Goshen does not. So there's a list of them, and if that becomes an issue, we can certainly guide you through that process.
And then the one that we haven't covered yet, right, is if you are in a nursing home, you're receiving care there, you are only permitted to keep about $50 per month of your income, plus any additional funds to cover your Medicare premiums or anything like that. But really not much income that you are permitted to keep. The excess over that $50 plus your premiums would get paid to the nursing home. Sometimes people confuse this. They think that Medicaid takes it or DSS takes it. It gets paid to the nursing home to cover a portion of the cost of your care, and then Medicaid picks up the additional expense. So if you receive $1,050 per month of income, you keep your $50, $1,000 goes to the cost of your care. But something I really want people to understand is that that's only $1,000 put towards something that may be a $10,000 to $13,000 nursing home bill. So Medicaid is still paying a good portion of your care there. So even though you can't keep all of your income, you are still receiving a nice benefit in that situation. So let's talk about spouses, because oftentimes we have a client who ends up needing Medicaid, needing some additional care, but not maybe not both spouses. Maybe there is one well spouse who's able to stay home. That well spouse, community spouse is sometimes known as, is also subject to some financial requirements, restrictions. So that well spouse is permitted to have a maximum amount of assets in their name of $130,380 of value. Again, we're not looking at the primary residence or vehicle or those retirement accounts. And then there's even a caveat to this we'll get to in just a moment. There's also a maximum amount of income that the well spouse is permitted to keep. So that's $3,259.50 this year of income that the well spouse or the community spouse is permitted to keep. Technically, the excess is supposed to go to pay for the institutionalized spouse's care, right? So that's why we have these requirements or restrictions. Department of Social Services want you to kick in something if you can. However, here in New York, we do have some exceptions. We have some spousal refusal exceptions, and we have some nice little tricks that we can do with the income specifically. So if the well spouse or the community spouse's income is less than the $32,590.50, so they don't quite reach that $32,590.50 number, Department of Social Services allows that well spouse to keep a portion of the institutionalized spouse's income so that they can at least keep of the total income between the two spouses, the $32,590.50 of income. So if that well spouse is only receiving $2,000 per month of income and the nursing home spouse is receiving $2,000 per month of income, the well spouse can keep all of their income, the full $2,000, and they can pull over another $12,590.50 of the nursing home spouse's income so that they are at least keeping that $32,590.50. So they recognize that you'll have some expenses if you're staying home and you're well enough, and that you need a little bit of income to live on. So they let you keep at least that amount. In addition to that, like I said, we have spousal refusal, and we've referenced this a few times. It's really nice benefit, a planning tool that we have available to us here and only here. So what spousal refusal says is the well spouse is essentially signing a statement and submitting that to Department of Social Services with the application, saying that I recognize that I have amounts in excess of what I'm allowed to have for my resources, or I'm allowed to have for my income, but I don't want to contribute my excess over to my spouse's care. I don't want to pay that over to the nursing home. I need that. I want to keep it. And so this written statement, like I said, goes in with the application. And then depending on the county that the application is being submitted to, it'll be received a little bit differently by each different Department of Social Services. Some of them, they say, okay, we see the spousal refusal. That's fine. You can keep all of your excess. We're okay with that. We're not going to ask for additional contributions. Other counties will ask for additional contributions, and they can even bring a lawsuit later on to request and receive additional contributions, which I do believe maybe we get to in a few slides. I'm not quite sure, but I see a few questions here too.
Yeah, I'm answering. Is spousal refusal an option in PA? The answer is no. New York is the only state it's fully operational. There's some modification or modified version of it in Florida and possibly Connecticut, but definitely not in Pennsylvania.
Right. So here on the next slide, you're going to see, like I said, with that spousal refusal, it allows the well spouse to keep the excess resources, the excess income above those limits that we've seen. And what that means is that they keep that and their spouse still remains eligible for Medicaid. So really, really nice benefit that we take advantage of very frequently here. And like I said, depending on where you are, Department of Social Services may request an additional contribution. So they may not say that you have to pay over all of your excess, but maybe 25% of your excess income. And then, of course, Department of Social Services retains the right to file a lawsuit for an additional contribution. So in case you haven't been able to identify some of the advantages of this so far, right? We're saying that we're trying to keep the excess, and then your spouse can still qualify for Medicaid. So what above and beyond that? What's the roll of the dice here, really? So we're saying we're submitting the spousal refusal. We don't want to submit the excess, and there is a possibility that you, as the well spouse, you won't get sued. So when you submit this paperwork, that's the end of the story. You get to keep all of your excess, and you're never expected to pay anything additional over. And frequently that is the experience we've had here in the lower part of the state. I do know I have some friends upstate New York, and I think probably even downstate New York, that's not the end of the story. So what happens if they ask for a contribution? Well, Medicaid reimbursement rate is only a percentage of the private pay rate. So if you're in a nursing home that's $12,000 per month, what Medicaid is actually paying is maybe $8,000 per month or something even less. Those are just examples, not specific numbers. So when Medicaid comes back to ask for a contribution, or they bring a lawsuit to receive a portion of the excess, they're only being reimbursed for what they've actually laid out, not the $12,000, which would be the normal private pay bill, but maybe the $8,000 that they have kicked in for the cost of care. And even at that, Department of Social Services will usually settle for less than the full amount paid by Medicaid. So if they paid $8,000, maybe they end up settling for $4,000 a month. So you still get a steep discount for that care that your spouse had received.
And all the caveats that Megan's talking about, Orange County, to our knowledge, has never brought a spousal support action in a Medicaid case. Other counties are much more aggressive. There are a lot of reasons for that. One is that the state keeps 90%, the county only gets 10%. Not a lot of incentive for the counties to devote, very limited resources to these things. That may change over time. We'll find out. So let's talk about the transfer of assets for Medicaid and how that all plays in. So bottom line, if you make non-exempt transfers, meaning not to a spouse or to a disabled child, which are also exempt transfers, if you make any non-exempt transfer within 60 months of applying for nursing home Medicaid or community Medicaid beginning in January, there will be this penalty period imposed during which you will not receive Medicaid coverage. There are a few exceptions to the transfer penalties. I mentioned one, you can transfer assets to a spouse without imposition of a penalty period of any amount. However, you can't have, okay, we're going to give everything from husband to the wife, and then have the wife give the money to the kids directly. Any transfers by a spouse to the children or third parties before the other spouse has been qualified for Medicaid will affect that applying spouse's Medicaid eligibility. However, once the spouse who needs the care is on Medicaid for at least 30 days, then the community spouse can engage in their own planning, whether it's setting up a Medicaid trust or just making transfers of assets to the kids without affecting the current or future Medicaid eligibility of the applicant's spouse. So there are ways around those limitations too. Excuse me. Another good exception is transfers to a supplemental needs trust for the benefit of a disabled child or a grandchild who is under the age of 65. Will not create a Medicaid penalty period. I'm doing one of these right now where the mother is just entering Valley View. She has one child who has severe mental issues. We set up a supplemental needs trust. She's going to transfer all her assets to that trust. She's a single person, and that will not affect her Medicaid eligibility. There are a number of exempt transfers of a home that are available. You can transfer your home, again, it has to be your primary residence, without any penalty period to the following: your spouse, but that goes for any assets, a child under the age of 21. I've had one case where this applied about 10 years ago or so. Had a fairly young woman under 60 who had unfortunately mental issues, was in a nursing home. She had a 20-year-old daughter. We actually were able to transfer her home up in Ulster County to that 20-year-old daughter, no penalty period. a blind or disabled child of any age. And that could be outright or in a trust. The fourth one, a sibling with an equity interest who had lived in the home at least 1 year. And what's really important about that is that they don't really actually have the title on the deed. If they can show, or their counsel can show, that they've been contributing towards the taxes or paying, into the cost of the property over the years, that is deemed enough to create an equity interest, allowing that transfer to that sibling. And the one that we see most often is the caretaker child exception. You can transfer title to a child who has lived in the parent's home for at least 2 years prior to the date of applying for Medicaid. And if that's the case, then it can go into that child's name. The deed can be conveyed without a penalty. The public policy reason for that is because it is assumed that on account of that child's assistance to their parent, they kept the parent from needing long-term care for a longer period of time than if the child had not lived there. So the government says, we're going to give you a bonus for doing that. We're going to allow that home to be put into your name. And so that's the exception to the one of the rules. Now, that doesn't always work in perfect context with what the family estate planning was. If the plan was the house to go to all 3 kids, in this case, it can only go to 1 child. Now, they may agree to then do a deed subsequently to put their siblings on title, but they may not. So it's not always a perfect solution, but in a crisis, it's certainly one that we want to have at our fingertips if the facts play out for that. Then there are some other exceptions to the rules. Well, you can sell an asset for fair market value. So if your house is worth 300 and you sell it for 300,000, that doesn't create a penalty. It really hasn't done a lot other than it's created some liquidity, because now you still have the 300,000 cash in your name. You haven't really reduced your assets. The next one is can be very helpful in a crisis case. If we have circumstances where assets are transferred exclusively for a purpose other than to qualify for Medicaid. So this is a very fact-specific kind of analysis. Classic case is, we have a 78-year-old widow who was in perfect health. 3 years ago, one of her kids was going through divorce, so she gave her son $30,000 to help him pay his legal fees. Happens a lot. Well, now she has a massive stroke, goes to a nursing home. Ordinarily, that $30,000 transfer would definitely cause a penalty period. But if the facts show at the time she wasn't thinking long-term care and her son had this genuine need, you're going to probably win that case if it goes to a fair hearing, and that transfer will not be a penalized transfer. And the last one, which is on the books, but which is sort of silly, imposition of a penalty would cause undue hardship. Well, of course it will cause undue hardship in that you are not going to get Medicaid during the penalty period. So this one doesn't really work in the practical world. If you try to assert it, you're going to have a very difficult time winning this. I guess the one case that you see there where it applies, if you made a gift to your kids and they promised they were going to keep it in a separate account to be used for your care, but then they went to the casino in Monticello and blew all the money, you might have a small chance of winning that argument. So before moving on to planning for non-exempt transfers, there were a couple questions. Megan, did you address those yet?
I'm addressing, yep, I'm taking care of them.
Okay, good. So Megan will deal with those questions now. So now we're going to talk about, we've talked about the exempt transfers and the exceptions that we have. Let's talk about how we plan when we don't have any exempt transfers available. We used up all our exempt transfers. So the first one is, what is the impact of making transfers during the penalty periods? Well, the soon to be in effect 30-month community Medicaid look back and the currently in place 60-month nursing home Medicaid look back periods applies for transfers that are made directly to third parties or into most types of trusts, other than some of those exception trusts like the supplemental needs trust that we talked about. It is a snapshot. you apply for Medicaid, the Department of Social Services will look back. Let's just talk for nursing home in this context. They'll look back 5 years from the date the application is submitted. If a transfer is made 5 years and 1 day before then, it is not in the picture. So we have a penalty period that we're going to be looking at. So let's talk about how the penalty period is calculated. Megan, I'll let you run with that.
Sure. So, and we kind of alluded to this a little bit earlier in the program, but what we're doing is we're taking a look at the total value of all of the uncompensated non-exempt transfers. So the gifts, you didn't receive anything in return or in exchange, and they don't fall within one of those exemptions or exceptions that we had talked about. We're going to tally up the total value of all of those gifts made during the look back period. So if you're applying for community, like we said, that's a 30-month look back period. Nursing home is the 5-year look back period. So again, we're looking at that snapshot, tallying up the total value of all of the transfers made, and then we're dividing that total number by the average monthly cost of a nursing home as established by New York. So we're the red region, the northern metropolitan. So you're familiar with this number already. So our divisor is that 13,206. And this is true, like we said earlier, this is true whether it's nursing home Medicaid you're applying for or community Medicaid. So if you've given in that snapshot date, that those months, that look back period, you've given $100,000 worth of assets away, and they were uncompensated and non-exempt, then we use this divisor, the 13,206. I think we end up with like a 7.5 month penalty period.
Months. Yes, that is correct.
Okay. And so what that penalty period means is that as of the date of this application, you are eligible for Medicaid, but because you're incurring this penalty period, Department of Social Services is not going to cover your care for that amount of time. So the penalty period begins to run on the date the Medicaid application is filed, but you must be otherwise qualified. You must have already met the other financial thresholds. You're at or below the $15,900 and you need the care. For community Medicaid eligibility, and again, this is something we emphasized earlier on, when you're applying, you not only have to meet those financial thresholds, but you actually have to show that you need that care by way of that functional assessment. So it can't just be that, you're kind of struggling and you think now's a good time to apply. You actually have to show that you're needing the care. Once you've met that criteria, then your penalty period begins to run. So you can't sort of like try to run the period out on yourself or anything like that. If you're pre-planning, you should just pre-plan. Under the new community Medicaid look back rules, the transfers made before October 1st, 2020 are still fully exempt. They fall sort of prior to the new rule. And so they're not going to be subject to the look back period, or a penalty period wouldn't be incurred from those. It's still unclear how the Department of Health is going to begin implementing this new community Medicaid rule. Like we said, the date that we're looking at is the January 1st, 2022 date, but this is a date that has moved several times prior to today, and so it's possible that it could get pushed back even further. And even once that date becomes effective, so say it's the January 1st, 2022 date, and now it's effective, the penalty period is only going to apply to transfers on or after October 1st, 2020 to start. And then once we have slowly inched our way up to the 30 months, it's going to just be the full 30-month look back period.
They add the slash and then update the version when typos.
Okay, so now we have some kind of tools and options available to us. If we are in a situation, maybe you or your loved ones, hopefully not you guys, but maybe loved ones or people you may know, if you're in a situation where suddenly you need Medicaid, you need some kind of long-term care, you want Medicaid to pay for it, but no real proactive planning has been done, or we didn't make it through the full look back period for that proactive planning to take effect. So we still have options. We can still preserve assets, even if you don't do the Medicaid Asset Protection Trust, although the Medicaid Asset Protection Trust is going to preserve a lot more than some of these crisis strategies would. So we can use things like loans and annuities. Using a Medicaid qualified loan is often used in crisis Medicaid planning. And typically it's a situation where you don't immediately qualify for Medicaid to pay for the care, but you don't want to spend down all of your assets to pay for your care before qualifying for Medicaid. So oftentimes we have a situation such as this example. The parent has $200,000 of non-exempt resources, and that parent ends up making a $100,000 gift to their children, and they also make a $100,000 loan to a child or sometimes multiple children, but that can be a little bit cumbersome. So they're transferring the full $200,000 out of their name. A portion of it is considered a gift, which would incur a penalty. A portion of it is considered a loan. So the penalty period of about 7.5 months because of the $100,000 gift begins to run. But now that we've transferred the full $200,000 out of that parent's name, they are eligible. They're below the $15,900. So a portion of the gift incurred the penalty period. We are eligible. The loan that's been made to one or more children, those loan repayments start to come back to the parent, and they get applied towards the cost of that parent's care prior to actually receiving Medicaid to paying for that care. So the loan repayments plus whatever other income that that person may have, and all of this is getting factored in when we're doing these calculations. It's not just simply dividing it up half and half. We have a lot of things that we have to take into account for this to work just right, but the loan repayments and the parent's income are being used to pay for their care for the duration of that penalty period that they've incurred, the 7.5 months.
Right. And the reason, of course, we can't do the full 200,000 is that'll create a 15-month penalty with no money left to pay it. So we have to run this calculation to see what the max amount of gift we can make, factoring in again the parent's income, and someone who has 6,000 a month of income versus someone with 1,000 is going to be able to gift more because they have more income coming in to cover the penalty. So it can really vary. But so this is, called a half a loaf plan, but sometimes it's 3/4 of a loaf.
Yeah.
Right. But it's never really less than half.
So, and I do think someone just sent in a question. I think we're answering it right here for you. So not only is there some math, some number crunching that needs to be done, but the loan itself has to be a Medicaid qualified loan. It has to have the appropriate terms in it for it to work and to make this parent eligible. So the loan has to be repaid with interest. Can't just be an interest-free loan, as much as you would love to do that, right? Has to be repaid to the parent with interest. And it also has to have repayment terms that are within the parent's life expectancy. Obviously, if they pass prematurely, but there's life expectancy calculator and things like that that would be used to figure out what their life expectancy is, what's reasonable, and the terms of the loan have to be within that life expectancy period.
Yeah.
The repayments have to be in equal installments. So we're not going to do little teeny tiny dribs and drabs to start and then have a balloon at the end or anything like that. They have to be equal installment payments. And that's important too when we're trying to figure out how are they going to pay through the penalty period. We want to have a number that we can count on. It has to be a non-cancelable loan on death of the parent, and it can't be assignable either, a non-assignable loan.
Right. So a couple of things here. First of all, the interest issue, especially in this environment, is no big deal. We can use the applicable federal rate, which for a short-term loan, which these almost always less than 3 years, is like 0.303%. It's like peanuts. You may have on a $100,000 loan, $50 of interest paid over the course of the loan. It's crazy how little it is. Life expectancy, that's always going to be within life expectancy because if we're talking less than 300,000 or 400,000, it's going to be paid over a couple year period. And where it's different from a traditional, say, mortgage loan is that it cannot be an assignable assignable note. Most notes are assignable. This one has to specifically be non-assignable. So you don't want your general real estate lawyer doing this planning because they're going to screw it up. That's just the reality. Okay. Then we're going to move ahead to pooled income trusts. Megan mentioned this earlier. This is really useful in the community Medicaid context, especially. So pooled income trusts are statutory trusts that are operated by various nonprofit entities around the state, and every state has them, that essentially pools excess income for many different people who receive public benefits. Essentially, the pooled trust trustee establishes a separate sub-account for each beneficiary that keeps their money separate. Currently, it is an option for community Medicaid only in New York State. There was a fair hearing case recently in Minnesota that seemed to open it up for larger nursing home cases. We don't know what impact that's going to have here. So what it really does practically is allows a person whose income is in excess of the current monthly community Medicaid income allowance of $904 to be transferred to a pooled income trust. So essentially what happens, so let's say someone has $1,900 a month of income, essentially $1,000 more. If they don't do a pooled income trust, they'll only get to keep $904. The other roughly $1,000 will have to go towards the cost of their care while they still have living expenses in their home and so on. So by using the pooled income trust, the beneficiary can have that excess $1,000 in my example go into the pooled income trust and then use to pay the rent or property taxes or their groceries and so on without having to go towards their spend down. And so here's a list of some of the expenses it can be used for. So the pooled trust distribution can only be used for that particular person. They cannot be allocated to a spouse or a child. So if someone's in an apartment and the rent is $1,000 a month and they're there with their spouse, the pooled trust will pay $500 of the rent, not a full $1,000 as a general proposition. But by and large, most people will have enough expenses that pooled income amount will be spent down every month and used up. If there is any excess at the time of the person's death, that will be retained by that charitable or nonprofit entity and will not go back to the family, but will instead be used for the charitable purposes. Not the worst thing. And the last major sort of topic in Medicaid, we're going to talk about our personal services contracts. Ordinarily, as a parent gets older and needs extra care, a lot of times the family members will step in and do things for the parent before they go to outside caregivers. The law presumes that if a family member, a child or grandchild, steps in and assists, that they're doing it out of love and affection. If they are paid without it being in a written agreement, those payments will be treated as gifts subject to the penalty rules. The only way really around that is to have a written caregiver agreement between the parent and the child or other family member that will allow for compensation to the family member for providing certain type of care and assistance. If it's in a written agreement, and it must be, as my next bullet point says, in writing, for reasonable compensation. So if in the community, a private caregiver on the books is going to be paid at $22 an hour, you can't be paid at $50 an hour for that same care. Has to be reasonable compensation. And what it also requires, you must keep good records. The payments must be on the books. You want to do tax withholdings or all that fun stuff. But it can be useful, and the child will, child or the third party will pay income taxes on the payments. But it can be very useful in the context, a scenario where a child either quits their job entirely or cuts back on their work hours to help mom or dad. Why can't we pay that child for the time so they hopefully will get the same or similar income that they were earning in their other job, and still helping mom and dad without having those payments constitute penalized transfers as it would be if there was no written agreement. So just another tool in our toolbox that in the right case can make a lot of sense. And lastly, because this is happening a lot these days, we run a close with scams targeting seniors. Basically, I just want to alert you, I'm sure a lot of people are aware there's a lot going on out there with scams. This is from the FBI website, all these bullet points of the most common scams that we're seeing out there today. The tech support scam, we get that a lot, where people are getting an email, oh, you know, your computer's been invaded. You have to let us get into your computer to fix it. If you don't verify that it is legit, and you got to do some digging on that, it is very likely someone wants to get into your hard drive and steal your financial information, and so on. The romance scam. You see this a lot, people on websites and, you know, dating, was it Silver Singles or something like that? I forget. You see them on the infomercials or the commercials, you know, 50 over 50 romance. There are a lot of people on those who will, you know, try to work on your weak spots and, you know, pretend to be romancing you and looking at a way to scam you. This is a very common one. We've seen it happen. People I know have been victimized by this. Their parents, the grandparent scam. You may have heard this. Grandma gets a call from, you know, grandson Joey. Grandma, it's Joey. I'm in jail. Oh, they don't even say their name. Grandma, it's your grandson. I'm in jail, but you can't tell mom and dad. You need to send me $10,000 so I can get out on bail. So these are people just fishing for people. They don't even again use their name. And unfortunately, so many times the elderly parent in a panic will run, and they ask to do it through like Western Union. They'll go and do it. We have one case where someone, again, I know personally, whose parent was at the Western Union office. Thankfully, the person there said, you have to tell your daughter, because of course the scammer says you can't tell your parent under any or can't tell my mom or dad under any circumstance. And they called up in the case I'm talking about, and they were able to stop it before the transfer was made. The government impersonation, you get the robocalls. Hello, this is the IRS. You have to send us your social security number or something, you know, something of that nature. Or you owe money and we're going to come and throw you in jail. The IRS doesn't call. They only do it in writing. That is a given fact. Another one we've seen happen, the sweepstakes, charity, or lottery scam. We had a woman who got had $2 million of assets. She ended up getting communicated by this guy who said his name was John Bradley. It was all done by text. He, I'm sure, was somewhere in like Uzbekistan or something like that. And before we were able to get a guardian appointed for her, she was out $157,000 in paying a fee to collect on the lottery she supposedly had won. The oldie that's been around pre-internet, the home repair scam. Oh, you know, we're going to come in and blacktop your driveway for $20,000, but you have to pay us in advance. Of course, they get paid and the people run off. What else do we have? Oh, the TV or radio scam, you know, use of illegitimate ads about legitimate services like reverse mortgages or credit repair. So again, if you don't see William Shatner on the commercial, it may not be a valid reverse mortgage thing. And then the one that, again, is very common, the family caregiver scam, where, you know, a family member, a niece or nephew or child who's already been named or convinces a parent, an elderly parent who's failing, to appoint them as attorney in fact under the power of attorney, and then takes advantage of their accounts. This is sometimes a harder one to nip in the bud because of the family relationship issue and the fact that we do want to appoint people to be our agents if we become incapacitated or infirm. This is where it might be beneficial to have two people acting together, that kind of thing, to minimize the chance of being taken advantage of. So just either for yourselves or certainly for elderly family members, really be on the lookout. There is so much fraud going on right now. It's frightening how much is happening.
Yeah, and just, you know, try to use common sense. If it sounds like it's too good to be true or somehow it's too easy, it probably is. And always independently vet everything. And I say this because even my brother, who's younger than me and he's supposed to be technologically savvy, these people are taking advantage of technology. They're really using it to their benefit. So never click the link in the email that you're not sure about, or never call the number in the letter or the email or the text message. Always go independently independently, find the 800 number to the appropriate company and call them separately and say, did you send me this? Just try to take those extra steps. Might be a little more work, but it could save you tens of thousands of dollars.
And just a week or so ago, my work email was hacked. People got these emails to click on a box, and if any of you got that, hopefully you didn't do it, because I don't know who it went out to. Hundreds of people, I think. And so we had to update our own internet security here. So they're very savvy, these crooks, and they're really bad. So we've answered, I think, questions throughout. Of course, as our clients, you can reach out to us as part of our update program. Ask us offline if there's anything further. If you haven't gotten it, and you may not have yet, anyone who registered for today should start getting your planning review worksheets and your funding worksheets. Obviously, you have to come in at some point to sign documents. I don't know if they've extended the remote signing. They probably have, but we are, at this point now, having people come in regularly with the vaccinations going on and so on that we've had to get everyone personally signed going forward. So hopefully you found this a good use of your time again and good information. There may be things happening throughout the year. For those of you we have your email addresses. We send out the stuff through our mass email through MailChimp it's called. So we'll keep you apprised as to any new developments as we go along. But again, a pleasure. We hope 2021 turns out to be a fabulous year for us all and a good, healthy year to everybody. So have a wonderful day. There's one question back in the box. What's the difference between the federal estate exemption and the annual gift tax? Well, the annual gift tax is annual. Right now, you can give $15,000 per year per donee without having to file anything. The federal estate tax exemption is a flat number of $11,700,000. If you gave $100,000 in gifts above your annual gift exemption, then your estate and gift tax exemption will be reduced from $11,700,000 to $11,600,000. If you need further clarifications on that, talk to us offline. But other than that, we're going to run. I have to go get my first haircut in quite a while. So we're going to check out now. And you all have a wonderful day and enjoy the beautiful weather. Thanks very much. Bye-bye.